My boss said, "I literally own you," so I made him prove it in court and destroyed his entire life. I'd been working at Meridian Financial Services for 4 years when my boss, Gregory Ashworth, said the words that would eventually ruin him. We were in his corner office on the 32nd floor, and I'd just told him I was declining to work the holiday weekend because my daughter had her first dance recital. "You don't get to decline anything, Nora," he said, leaning back in his leather chair that probably cost more than my car. "When you signed your employment contract, you agreed to be available whenever I need you. I literally own you." I stood there holding my folder and felt something shift inside me. Not anger exactly, but clarity. "You own me?" I repeated slowly. He smiled like he'd just made a brilliant point. "Contractually speaking, your time, your expertise, your output, it all belongs to me. That's what employment means. I own your productive capacity." I nodded and left his office without another word, but my mind was already working. If Gregory Ashworth believed he owned me, I was going to make him prove it in a court of law. That night, I pulled out my employment contract and read every single word for the first time since I'd signed it 4 years ago. It was 73 pages long, which should have been my first warning sign, but I'd been desperate for the job back then. Fresh out of my MBA program with student loans crushing me and a 6-month-old daughter to support a loan after my ex disappeared. I'd signed whatever they put in front of me without reading the fine print. Now I was reading it, and what I found made my hands shake. Clause 14.7 stated that any intellectual property, creative work, or innovation I produced during my employment belonged exclusively to the company in perpetuity. Clause 22.3 said I agreed to be available for work-related matters at any time, day or night, weekends and holidays included. Clause 31.9 required me to receive written permission before accepting any outside employment or starting any business venture. There were 47 other clauses, each one more restrictive than the last. The contract didn't just employ me, it owned significant portions of my life, my time, and my creative output. But here's what Gregory hadn't considered when he'd smiled at me in his office. If he truly owned me under this contract, then he was responsible for me. All of me. I spent the next 3 days researching employment law, contract law, and something I'd never heard of before called unconscionable contracts. Then I made an appointment with an attorney named Patricia Ogunwe, who specialized in labor disputes. She was a small woman in her 50s with sharp eyes and an even sharper mind. I sat in her office and explained what Gregory had said and showed her my contract. She read it in complete silence for 20 minutes, and when she looked up, she was smiling in a way that made me nervous and excited at the same time. "This contract is absolutely insane," she said. "Half of these clauses wouldn't hold up in court for 5 minutes. But if your boss genuinely believes he owns you based on this document, we can use that." Patricia explained her strategy over the next hour, and with each detail, I understood how perfectly Gregory had trapped himself. If he owned me, then I was effectively company property. And property requires maintenance, insurance, proper care, and compensation for depreciation. If I was his property under this employment contract, then he had responsibilities he'd never considered. She agreed to take my case on contingency, meaning she'd only get paid if we won, which told me she was confident. We spent the next 2 weeks building our case. Patricia had me document everything. Every email Gregory sent after hours. Every weekend he called me. Every vacation day I'd missed because of his demands. Every time I'd worked through illness because he said I couldn't take sick leave. Every instance where he'd critiqued my appearance or told me what to wear. Every personal question he'd asked about my life outside work. By the time we were finished, I had a file 3 inches thick documenting 4 years of Gregory treating me exactly like property he owned. The first move was simple but devastating. I stopped going to work. Patricia sent a formal letter to Gregory and the company's legal department explaining that since Mr. Ashworth had explicitly stated he owned me under the terms of my employment contract, I was now operating under property law rather than employment law. As company property, I required proper maintenance and could not be expected to self-report for duty. I needed to be transported to the workplace, maintained during work hours, and returned to storage at end of day. The company had 48 hours to arrange these accommodations or release me from the ownership clause. Gregory called my cell phone 37 times that first day. I didn't answer. Instead, Patricia sent another letter itemizing my maintenance costs as company property. The list included housing, since property must be stored properly; food, since property must be maintained in working condition; healthcare, including mental health services for the stress of being owned; clothing allowances, since property must be presentable; and a depreciation schedule, because property loses value over time and must be compensated accordingly. The total came to approximately $300,000 annually, not including my actual salary. Meridian's legal department responded within 6 hours, and their message was predictable. The employment contract did not literally convey ownership, and I was required to return to work immediately or face termination. Patricia's response was beautiful in its simplicity. She filed a lawsuit in civil court asking a judge to determine the exact nature of my relationship with Gregory Ashworth and Meridian Financial Services. Were we in an employment relationship governed by labor law, or did Gregory Ashworth own me as he'd explicitly stated? The complaint included the recorded conversation from his office where he'd said those exact words, because I'd started recording all our meetings 6 months ago after he'd stolen credit for my work on the Donovan account. Gregory hadn't known about the recording. Nobody did. But I'd been documenting everything since then, and his voice was crystal clear saying, "I literally own you," with absolute confidence. The lawsuit hit the local business news within 3 days, and that's when things got interesting. Other employees from Meridian started reaching out to Patricia's office. They'd signed similar contracts. They'd been treated the same way. Within 2 weeks, Patricia had 17 potential plaintiffs, all with stories about Gregory's management style and contracts that stripped away their rights. But we were the test case, the one that would determine how the others proceeded. The preliminary hearing was set for 6 weeks out, and during that time, I was technically on unpaid administrative leave. Patricia assured me that when we won, the back pay and damages would more than cover my lost wages. In the meantime, I had to drain my savings and pick up freelance work just to keep my apartment. My daughter kept asking why I wasn't going to work anymore, and I told her Mommy was fighting to make things fair. She was 7 and didn't really understand, but she seemed to accept that Mommy was doing something important. Gregory's legal team tried every tactic to dismiss the case before it got to court. They argued I was filing frivolously, wasting the court's time, misrepresenting the nature of employment contracts. But Patricia had anticipated every single argument. She'd built the case so carefully that each dismissal attempt just made Gregory look worse. The judge, a woman named Harriet Liu, who'd been on the bench for 20 years, seemed increasingly annoyed with Meridian's attorneys. At one hearing, she actually interrupted their argument and said, "Counselor, your client told this woman he literally owned her. Either he meant it and we need to determine what that means legally, or he didn't mean it and he's been operating in bad faith with his employees. Which would you prefer to argue?" The attorney went pale and requested a recess. That's when I knew we had something. During the recess, Patricia pulled me aside and explained what was happening behind the scenes. Meridian's insurance company was getting nervous. Employment practices liability insurance was supposed to cover cases like this, but the insurer was arguing that Gregory's statement about ownership moved this into territory they hadn't agreed to cover. If he actually owned employees, that wasn't employment anymore. It was something else entirely, and it wasn't in their policy. Meridian was facing the possibility of paying all their legal fees and any judgment out of pocket. The company's board of directors was starting to ask questions about Gregory's management practices and why he'd created these contracts in the first place. The preliminary hearing turned into a full evidentiary hearing because the judge wanted to understand the complete context. Patricia called me to the stand first, and I walked through my 4 years at Meridian. I explained how Gregory had gradually increased his control over my life, how he'd called me at 2 in the morning to discuss a client's portfolio and expected me to be lucid and professional, how he'd sent me emails at midnight on Christmas Eve and written me up when I didn't respond within an hour, how he'd criticized my clothing choices and told me I needed to look more expensive if I wanted to represent the firm properly, how he'd asked invasive questions about my daughter and my personal life, then used that information to manipulate my schedule, how he'd taken credit for my work on at least 8 major accounts while I was listed as a junior associate in the paperwork, how he'd told me explicitly that I couldn't take a second job or start a side business, even though my salary barely covered my expenses in the city, and how he'd said on multiple occasions both before and after the recorded conversation that he owned my time, my talent, and my productivity. Gregory's attorney tried to make me look vindictive during cross-examination. Wasn't I just upset about not getting promoted? Wasn't I known for being difficult in the office? Hadn't I actually volunteered for many of these extra projects? I answered each question calmly and truthfully. No, I wasn't upset about promotion because Gregory had never indicated promotion was possible for someone at my level. No, I wasn't difficult. I was thorough. And there were 17 other employees ready to testify about similar treatment. And yes, I'd volunteered for projects because refusing meant retaliation. And I had documentation of 3 instances where colleagues who'd refused Gregory's requests were fired within weeks for pretextual reasons. The attorney sat down faster than I expected. Then Patricia called her expert witness, a professor of labor law from Northwestern, who'd written 2 books on employment contracts and worker rights. He walked the judge through my contract clause by clause, explaining how each one exceeded normal employment terms and veered into indentured servitude territory. He used phrases like unconscionable restriction on liberty and effectively binding the employee beyond the scope of legitimate business interest. He compared my contract to historical examples of exploitative labor practices and made it clear this wasn't standard in the industry. Meridian's expert witness was some corporate attorney from New York who tried to argue that all of this was normal in high-level financial services. The judge asked him directly if he'd ever worked under a contract like mine. He admitted he hadn't. She asked if he'd recommend his own children sign such a contract. He hesitated, then said he'd want to review it carefully first. The judge actually smiled at that answer. Then came the part Patricia had been waiting for. She called Gregory himself to the stand. I watched him walk up there in his expensive suit, still confident, still believing he was going to explain his way out of this. Patricia started gentle, establishing his role at the company and his relationship to me as his employee. Then she played the recording. His voice filled the courtroom saying, "I literally own you," with such casual certainty that several people in the gallery shifted uncomfortably. Patricia asked him to explain what he'd meant by that statement. Gregory tried to walk it back immediately. It was a figure of speech. He'd been frustrated. Everyone talks like that in high-stress environments. Patricia let him dig for a while, then pulled out printed copies of 17 different emails where he'd used similar language with me and other employees. "Your time belongs to me. I own your output. You're my resource to deploy as I see fit." She asked him if all of these were also figures of speech. Gregory's face started getting red. He insisted he'd never meant literal ownership, that everyone understood this was just workplace terminology. Patricia nodded sympathetically, then asked why he'd included Clause 31.9 in the employment contract, prohibiting employees from accepting any outside work without his written permission. If he didn't own their time, why did they need permission to work elsewhere? Gregory said it was about preventing conflicts of interest. Patricia pulled out documentation showing that 6 employees had requested permission for completely unrelated part-time work, and Gregory had denied all 6 requests with no explanation. She asked what possible conflict of interest existed between working at Meridian Financial and teaching yoga classes on weekends. Gregory had no good answer. Then Patricia went for the throat. She brought up the Donovan account, where I'd developed the entire investment strategy, but Gregory had presented it as his own work and collected a $60,000 bonus. She asked if taking an employee's work and claiming it as his own wasn't exactly what an owner does with property they control. Gregory tried to argue that supervisors always present their team's work, but Patricia had emails showing he'd explicitly instructed me not to mention my role when clients asked questions. The more Gregory talked, the worse it got. Patricia asked about the midnight emails and whether he believed employees had any time that belonged to themselves. He said that high-level financial work required availability. She asked if he paid for that availability beyond the base salary. He said the salary covered it. She asked how a fixed salary could cover unlimited hours, and he didn't have an answer that didn't sound like exploitation. By the time Gregory left the stand, he looked exhausted and angry. The judge called for a 30-minute recess, and when we came back, she had clearly made her decision. She stated for the record that while she did not believe Mr. Ashworth literally owned me in the legal sense, his behavior and statements showed he believed he had a level of control over my life that exceeded normal employment boundaries. The employment contract contained multiple clauses that were unconscionable and unenforceable. She was voiding the entire contract as written and ordering Meridian to provide me with back pay for all overtime hours worked beyond standard full-time employment for the past 4 years. She also awarded damages for emotional distress and ordered Meridian to cover my legal fees. The total came to just over $400,000, but she wasn't finished. She ordered Meridian Financial Services to submit all their employment contracts for review within 30 days and to revise any similar clauses. She was referring the matter to the Department of Labor for investigation into whether Meridian's practices violated federal labor laws, and she was ordering Gregory Ashworth personally, not just the company, to pay an additional $50,000 in punitive damages for his statement about ownership and his pattern of exploitative behavior. Gregory stood up and started yelling that this was insane, that she was destroying his career over a misunderstanding. The judge told him to sit down or she'd hold him in contempt. Security actually moved toward him before his own attorney pulled him back into his chair. The courtroom was completely silent. Patricia squeezed my hand under the table, and I realized I was shaking. Outside the courthouse, reporters were waiting. The case had gotten attention in the legal community, and now it was spreading to mainstream news. Patricia gave a brief statement about worker rights and the importance of reading employment contracts carefully. I didn't say anything. I just wanted to go home to my daughter. But the story didn't end there. Within a week, 3 more lawsuits were filed against Meridian by other employees Patricia had been talking to. Within 2 weeks, the Department of Labor announced a formal investigation. Within a month, Gregory Ashworth was placed on administrative leave by Meridian's board of directors. The company was facing serious financial and reputational damage, and Gregory was the obvious scapegoat. He hired a crisis management firm to try to rehabilitate his image, but it was too late. Someone leaked internal company emails showing that Gregory had been warned by HR multiple times about his management style and had ignored every warning. Someone else leaked information about his expense reports, which showed he'd been billing personal expenses to the company for years. The board voted to terminate him with cause, which meant no severance package and no stock options. Gregory had worked his way up at Meridian for 15 years, and he lost it all in 6 weeks. His wife filed for divorce 2 months after the verdict, citing his revealed character and financial instability. His name became shorthand in business circles for employment abuse. Articles were written about Gregory Ashworth contracts and how to spot exploitative clauses. Law schools started using my case in their employment law courses. Patricia told me later that she'd never seen a single lawsuit have such immediate and widespread impact. The Department of Labor investigation eventually resulted in Meridian paying over $2 million in back wages and penalties to current and former employees. The company implemented entirely new employment policies and contracts. They hired an outside firm to audit their practices and retrain management. Meridian survived, but barely, and it took them years to rebuild their reputation. Gregory, meanwhile, couldn't find work anywhere in financial services. He tried consulting, but nobody wanted to hire the man who'd become famous for saying he owned his employees. He started a blog about leadership and management, which was almost immediately mocked across social media. Last I heard, he was working in sales for a mid-sized insurance company in another state, making a fraction of his former salary. His entire life had been built on his reputation and his position, and both were gone. I used the settlement money to pay off my student loans, buy a small house in a better school district, and start a college fund for my daughter. I also invested in Patricia's practice because she'd started focusing exclusively on employment rights cases and needed capital to take on more clients on contingency. We became business partners and friends. I went back to school and got a law degree myself, which took 3 years while working full-time as a financial analyst at a different firm with a reasonable contract. Now I work alongside Patricia, representing employees in cases similar to what I went through. We've won most of them. The ones we don't win usually settle before trial because companies have learned from what happened to Meridian. My daughter is 12 now, and she knows the whole story. She knows why Mommy fought back and what happened when someone tried to claim they owned another person. She's learning about standing up for herself and others, about reading contracts before signing, about understanding her worth. Sometimes former Meridian employees reach out to thank me. They tell me their lives are better now, that they have time with their families, that they're not answering emails at 3 in the morning anymore. A few of them have become advocates themselves, speaking at conferences about worker rights and contract fairness. The case created ripples that are still spreading years later. Gregory tried to sue me once for defamation, claiming I'd ruined his reputation by lying about him. The lawsuit was dismissed within a month because everything I'd said was documented and proven in court. His attorney withdrew from the case and suggested he stop pursuing legal action before he made things worse. That was the last I heard from him directly. but I see the impact of what happened everywhere. Companies are more careful now. Employees are more aware. There are organizations dedicated to reviewing employment contracts for workers who can't afford attorneys. Law schools teach entire courses on exploitative employment practices. And whenever I speak at conferences or to student groups, someone always asks about Gregory and what happened to him. I tell them the truth. He built his career on believing he could own people's time, labor, and dignity. When forced to prove that belief in court, he couldn't, and everything fell apart. His life wasn't destroyed by me. It was destroyed by his own words and actions. I just made sure those words and actions were examined in the light instead of hidden in corner offices and intimidating contracts. Sometimes I think about that moment in his office when he leaned back in his expensive chair and told me he owned me. He was so confident, so certain that his position gave him unlimited authority over people beneath him. He never considered that someday someone would take him seriously and demand proof. That's the thing about people who believe they own others. They're always surprised when the property fights back. My daughter asked me recently if I regret how everything turned out, if I wish I'd just found a different job instead of fighting. I told her that some battles are worth fighting not just for yourself, but for everyone who comes after you. Gregory Ashworth said he owned me, and that statement revealed everything wrong with how he treated everyone who worked for him. Making him prove it in court didn't just free me, it freed dozens of other people and changed how companies think about employment contracts. That's worth every difficult moment. Last month, I got an email from a law student who'd studied my case. She told me she'd just convinced her first employer to remove several problematic clauses from her contract before signing. She thanked me for showing her that employees have power and that contracts are negotiable. I saved that email. I have a folder full of similar messages from people who've used what happened to me as leverage in their own situations. None of them had to go to court. They just had to know it was possible to fight back. That's Gregory's real legacy. Not his career or his reputation, but the knowledge that no one owns you just because they sign your paycheck. And if they claim they do, you can make them prove it. And watch everything they built come crashing down when they can't. I'm not owned. I never was. And neither is anyone else. Thanks for hanging out till the end. If you want more stories, make sure to subscribe and leave your take below.